Good afternoon. I'm just going to talk loudly. The Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of December 5th, 2019. My name is Emily Lamb, and I will be presenting the cases to the board for their review in today's public hearing. Members of the public at this time, please take a minute to turn off your cell phones or other devices. Make sure they're silenced so that the board can hear cases without interruption. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has oppositions, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the originally allotted 10 minutes. At the conclusion of the hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire zoning code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville network, it's imperative that anyone addressing the board please come forward to the front table and speak into the microphone. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of a BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board decision becomes final and no further action can be taken. If your appeal is granted, you're required to obtain a permit, the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals. First case 2019-449 has been withdrawn. Okay. Next case 2019-461 has been withdrawn. Next case 2019-491 has been withdrawn. Thank you. Case 2019-490, did I announce 491? That was withdrawn. Case 2019-495 has been deferred to January 16th. And case 2019-501 has been deferred to December 19th. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, the case is then recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for a consent, please raise your hand, make sure I see you. We'll remove it from the consent agenda and hear it in its regular order. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First case 2019-490 involving property at 7400 Highway 70 South. Is there anyone here in opposition to case 490? Seeing none, next case 2019-493 involving property at 111 Westover Park Court. Is there anyone here in opposition to case 493? And finally, case 2019-498 involving property at 305 Gallatin Pike South. Is there anyone here in opposition to case 498?
Yes, sir.
All right, we will hear that case in its regular order. So, Mr. Chairman, that leaves two cases on the consent agenda, case 2019-490 and 493.
All right, we have a motion for those two items on the consent. Is there a second? There's a second. Is there any discussion? All in favor, say aye. Aye. Any opposed? The consent agenda passes.
Members of the public, if your case was just approved on the consent agenda, you are free to go. Please give our staff until Monday to process all the documentation associated with the permit for which you applied, at which point you can come in to pursue those permits. Mr. Chairman, before we move on to cases to be heard, we would like to take the opportunity to recognize any elected officials who are in attendance. Councilmember Hauser, would you like to speak?
I was just here in support of them.
All right.
Thank you.
I don't believe there are any other council members here. So absent any other announcements, we're ready to begin with the cases to be heard.
First case.
First case for the board to consider is case 2019-492 involving property at 908 Cheatham Place. This is a request for a variance from side setback and lot size requirements to construct a single-family residence. Is the applicant here for this case? You can come to the front table. Before you is a zoning map showing the zoning of the property is R6A. This is the aerial photography giving you the sense of the surrounding area. This is the site plan submitted by the applicant. And finally, you see the current conditions of the property. Is there anyone here in opposition to case 492? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address. And before you speak, Mr. Chairman, I would like to let you know we received an email from the council person today supporting this application.
Yeah, just turn other button. Red
Hello?
button's on.
Oh, sorry. My name is Kent Basel. I'm applying for a 908 Cheatham variance. I am applying because of the lot requirements. The square footage is the minimum, I think, for an R6A is 3,750. When I purchased the lot, I was under the impression that it did meet that requirement. After looking into further and getting a survey, the lot is actually 37 by 100, so it's 50 square feet short of the requirement by the city. I think this overall is like less than 2% of what we're looking at. Maybe we're splitting hairs, but for me, I'm just applying to make sure that it meets, that I can actually build on it. I've spoken to the councilman. He is 100% in approval. He thought that, these variances are for situations like this. I mean, if you can see, there's nothing on the block. And from the east and west of my lot, there's nothing there. And I feel like, looking to developing, this is kind of, would be a benefit to the neighborhood. But
What the you're also asking for a setback, and I think that, as I understand it, because it's a substandard lot, you have to build to within 3 feet of the side. And what would you like to build? What would you like your side setback to be?
if you look at that, when I did made those plans, I wasn't aware of those certain setbacks, and when I applied for it, that was just an additional, I'm okay with, changing those setbacks to meet, the councils or whatever y'all wanted to do. I just had already been in.
Yeah, but
I think it's like 20%.
What is my question is, how far off are you? What is your setback as you have proposed your plan?
I think it's like 3.5 feet on both sides is what I proposed. And I think that the required thing is you have to have it for the first 40% of the building. of the structure. It has to be all one, if it's 3.5, it has to be 3.5-foot setbacks for the first 40%. And I think if you see on the front right there, I have a little cutout. So that was one of the additional things that I applied for, is just to have that.
But just so, for the board's sake, though, you're asking for, your building it will be further away from the property line than is required by code at this point. Is that correct?
It's going to be further away from,
the property line. If you built the whole thing.
The 3-foot is a build-to line.
Right.
Yeah. So he's building some of it away from the 3 feet. That's
Right.
what he's required.
So it'll
to
be
build.
further away from the neighbor is what I'm saying.
yeah. It's not going to be closer. It's just,
Yeah, most people that come and ask for setback variances want to be closer to the neighbor. In this case, you're wanting to be further from the neighbor.
Yeah, it was just kind of how the structure was already designed, and then they were like, well, we wanted the first 40%, so
Yeah,
I just said.
The build-to setbacks are just, we don't hear very many of them, and it's just a strange concept for most of the ones that we hear. So I just want to make sure everybody, that I understood and that everybody else understood exactly what you were proposing, which was to be further away from the neighbor by not having the setback as long as it's required to be at 3
Correct.
feet. Okay.
Correct.
All right. Anything else you'd like to add right now? Are
That's
there
it.
any questions from the board? All right, we will close the public hearing. Thoughts?
Well, it's a very small ask. It's only slightly shy of the requirement. And for the side setbacks, he's not wanting to build like most people do, as you were trying to point out, or as you had pointed out, that he's not trying to build closer to his neighbors. So I think it's an acceptable variance request.
A motion?
I will move to approve the variance request for the lot size and for the 3-foot build-to line.
Have a motion. Is there a second? I have a motion and a second. Is there any discussion? All in favor, say aye. Raise your hand. Any opposed? That motion passes. All right. All right, that passes. Good luck. Next case.
Next case is 2019-498, involving property at 305 Gallatin Pike South. This is a request for a variance from distance requirements in order to obtain a permit for an existing automobile repair shop. Before you is a zoning map showing the zoning of the property as CS. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant, and finally, the current conditions of the property. There is opposition here. Each side will have 10 minutes to make your presentation. Please be sure to identify yourself by name and address before making your presentation.
Just make sure press a button until the red light comes on. There you go.
Okay. Good afternoon. My name is Chudi Chedabu. I'm here with Ms. Diana Cruz and Delshad Ibrahim today. On behalf of AutoStop Incorporated, we're here regarding the variance request. A little background on this story is Ms. Diana Cruz and Delshad, they're the owner and the general manager of AutoStop Incorporated. Ms. Diana Cruz's parents, they own the building at 305 Gallatin Pike. They currently lease a part of the building to a grocery store and another one to a beauty clinic. And there was a 3,500 square foot garage space in the back, which had not been used, was really just used for haphazard storage and all types of stuff. It was pretty bad back there. There was dead animals, all types of stuff. It was an eyesore, really. And earlier this year, Delshad and Diana, they decided to start AutoStop and use that space, cleaned up the space, and used it as a automobile repair shop. They repaved the driveway, they cleaned out the whole entire interior space, they put some color on the building, and just overall made it presentable to be an automobile repair shop. Thereafter, they started business towards the end of August and beginning of September, and they got the advice from certain professionals that they were legally compliant. And around October 4th, they got a stop work order for not having a use and occupancy permit. And we went to file for the use and occupancy, and they denied it because of Provision 9, which was enacted last October, in which they cannot have an automobile repair shop within 1,320 feet of another. So we applied for this variance. The reason the board should grant this variance is because there is no other reasonable commercial use for this particular area of the building due to the way it is designed, particularly the garage door height and the dock area being 31 feet or 30 feet back from where the garage doors are. The only entrance to the area is 2 garage bays, so it's clear that this area was designed to be a commercial garage space, and this provision denies pretty much a third of that building from any productive use for Mrs. Cruz's parents. And in addition to that hardship, AutoStop, the fact that AutoStop has been a benefit to the community because it has cleaned up the area, that particular area. It was really an eyesore before they developed it and made improvements, which kind of cleaned up that whole entire area near Hickory Street and Gallatin Pike. There was also a problem with parking on Hickory Street and Gallatin Pike, which many people were filing complaints with the city about. And ever since AutoStop got there, they've been able to enforce the non-parking on the street in front of there because that's their property, and it's been able to clear up the street and the roadway, and it's been a benefit to the community in that way. We also had Councilwoman Tanya Hancock of District 9. She came out to the property, and we discussed some of the improvements we have made and some of the ones that we plan to continue and make if the board grants this use and occupancy permit. And she was with full support. She gave us full support. She also sent y'all an email, a letter, which expressed that support of how we should continue to improve this property because certain other properties around it, it kind of just makes the community look ugly. And this is actually a benefit to, AutoStop being here is a benefit to just the aesthetic of the neighborhood as a whole. So because the councilwoman agrees and supports that we should be able to operate this auto shop here, and due to the fact that the garage door height and dock area, the way the whole garage is designed is pretty much for it to be a commercial service space. The only other fathomable
question, do you,
yes,
I read somewhere that, I guess maybe it was from the council person, that one of the things that you all, and I think she had expressed a concern over the Hickory Street, and it said that, in the park, not a concern over your place with Hickory Street, but the parking on Hickory Street, and it said that you all had planned, either you've done it or you plan to do it, and I think it was on the drawings you submitted to put in some type of barrier or a fence or something that would further beautify the neighborhood and also would go a long way to prevent people from illegally parking on Hickory. Is that something that's still part of the plan, or
yes,
what's the status of that?
Yes, sir, absolutely. We've been able to get 2 contractors out there, and we got the quote. We submitted one of the quotes with the application, but the reason we had to submit that one was because we got notice. We had to submit the application pretty quick because of the timing with everything. But we plan on getting some more contractors out there to give us quotes. Ideally, we want a brick wall, which would separate the parking lot from Hickory Street. Right now, we have it's like a metal chain link fence kind of that's separating it at the moment. But as we discussed with the councilwoman, if we were able to get this use and occupancy permit, we would definitely continue to discuss and try to implement some type of wall right there. And yeah, with the councilwoman's support and being that the whole entire garage is designed particularly to be a commercial repair space, and the fact that not allowing that would effectively deny the productive use of almost a third of Mrs. Cruz's parents' building, we believe that the board should grant this variance, and I would like to reserve the rest of the time for rebuttal.
Super. And do you know, has it been a repair shop at some point in its history, or is it, what's the history of that space?
From what I know, it's been mainly just storage. It was used because a part of that personal storage was in there was 2 abandoned cars. I believe, I don't know for sure, but I believe they bought the building in that condition. Well, not as bad as it was this year, but in a somewhat like it wasn't being used, that condition. So, yes, I believe.
I mean, and it looks like a repair.
Yeah.
So, All right, great. Any questions for the applicant at this point?
Yes, sir.
If the variance is granted, how far will you be from the property line of the nearest automobile repair establishment, automobile sales establishment?
Well, there's a Firestone across Gallatin Pike on that side, and then there's another automobile repair shop on the corner of across from Hickory Street.
Okay. Do you know which one is the closest to those, and approximately how many feet away would you be?
I would say approximately 20 to 25 feet, maybe 30. Oh, well, they informed me it was about 100 feet actually across the street.
Are you sure it's not more like 100 to 150 feet?
I was just thinking about the street because it's probably 100 from where our property starts to theirs. Where their property starts is probably about 100 feet.
Property line?
Well, the property line, I was thinking there's one right across Hickory Street. So that's why I was thinking about 20 to 25 feet, but they just informed me the actual.
That's the nearest property line.
Yeah.
Gotcha.
Okay.
Thank you.
You're welcome.
Stated in your opening comments that someone had advised you that the property was, there we go, that the property was, you'd been advised that it could be used for this, it would be available?
Yes, sir.
for
It
use?
was, they just
Who was
advised-
that? Who was it that told you that?
Well, they had their accountant who pretty much set up everything for them, and they said that they would be legally compliant, but
So it was the accountant, it wasn't anybody with Metro or anything like that?
well, there was one man, but he wasn't currently employed with Metro, but he said it would be good. But that was after we had received this order.
Okay.
Any other questions at this point?
So, yeah, that's-
All right, we will save the rest of your time for rebuttal. And we will hear from the opposition.
Thank you.
Thank you, members of the board. I'm Larry Hoover. I'm an attorney here in town with offices at 1222 16th Avenue South, Nashville, Tennessee. I represent a property owner that is within this 1,300-foot radius. They respectfully oppose this variance of the.
Who is the property owner?
Is it mandatory that I disclose that?
I think it gives you more credibility. I mean, I
think it should be disclosed.
All right.
I don't know what the law is on that.
Well, they have concerns about being identified in this situation.
Usually the purpose of identifying yourself by address is to prove that you have standing to bring the I want to say the lawsuit, but certainly to show that you have an interest in the property. So if it was to go up on appeal, so I guess he stated that he's within a certain amount of feet. But I think if he could at least give an address, I think that'd be preferable.
Yeah.
We've got an attorney who is swearing to the board that he represents a client that is within the area. I don't think you should put him on the spot by making him disclose if this client would prefer him not to. I've got a little bit of a problem with doing that. I mean, if he will tell us, I mean, to do otherwise is an unethical act, and he can get himself in a whole lot more trouble by doing that. Just as an attorney, if my client said, I don't want to be disclosed, I'm not going to disclose it. And I don't think you can take and weigh that into your decision one way or the other if he is admitting that his client is within the permitted area. At least I don't think you can.
I would weigh in on that for purposes of appeal. Maybe if we just ask Mr. Hoover to submit that quote under seal in an envelope, and therefore the address is part of the file, if y'all are agreeable to that.
I think that at this point,
No.
I'd be happy to let you make your case, and we can, again, this isn't a court, but we can weigh it as we.
I apologize. What was the?
Well, I was suggesting that we could have Mr. Hoover submit for the record the address under seal. He stated that it is within the a proper square footage, but that way we have it. I don't know if that affects the public aspect of this hearing, but it seems it would
I
address
think
that
anything
concern.
he submits becomes a public record.
Right.
I mean, I think he could submit it under seal for the purposes of not revealing it today, but if and we wouldn't release that, but if we get a
Right.
public records request, I don't think we have any basis for not turning it over. So it kind of buys them some time, and if nobody asks for it, then no harm, no foul. But if somebody asks for it, I don't think that we can withhold that.
Can you live with that, Mr. Hoover?
Understood. I can live with that.
Well, and yeah, I've been on this board 8 years. I've never had anybody come to this board and ask to give their opinion without being named, other than sometimes people do submit anonymous letters of support or opposition, which are weighted accordingly. So state your case.
There again, members of the board, we would respectfully oppose the variance to the 1,300-foot rule. What we would like to explain or get across to the board is this is a heavily and highly congested area. There are more than one used car dealerships within 1,300 feet. In fact, there's one within, as the board mentioned earlier, 100 feet.
Are you talking about auto repair? Or you said
Auto repair and used car. Actually, I was going to talk about both. There's more than one auto repair shop within 1,300 feet. There's more than one used car dealership within 1,300 feet. It is such a congested area. It sometimes draws the ire of the codes folks that come out and have to straighten out that situation. I've represented a lot of repair shops in the past, and I've rarely seen one that didn't overflow their lots with cars that need to be repaired, because that's how they do their business. Again, we respect a person's rights to open up their own business and make a living. We don't want to impair that. But again, I'm just here representing my client and stating that we just respectfully oppose it due to the amount of businesses that are used car dealerships and repair shops that are all within that same regulation. And they're not just, at 1,000 feet away, they're 100 feet away. And they're proposing to add yet another one to that situation. So that would be my statement.
Well, Mr. Hoover, what impact, when you say congestion, we don't know where within that 1,300 feet your client falls. So you're just saying, is it just a general objection to having another repair establishment?
You're talking about Hickory Street, you're talking about Bronner, and these areas through there. Those are the areas where the used car dealerships and the repair shops are at. That's where the congestion is.
You mean traffic congestion?
No, I'm talking about parked.
Congestion
I'm sorry, I didn't do a good job of that. I'm talking about parked cars that are either in the process of being sold or in the process of being repaired.
Okay.
So is the council lady's suggestion and the intent of the applicant to build a wall, which would certainly be, I think, a condition of approval, would that not alleviate the illegal parking and congestion concern that you're raising?
I wasn't aware of the council lady's recommendation of this, first and foremost. I'll say that. If that's to be done, and they did not add any additional, as I keep using the word congestion, to that area, it'd be hard for me to oppose it or complain about it at that point. Yes, sir.
It seems like that. Again, just looking at the pictures and the undeveloped nature of the street in terms of no sidewalk, no curb, that it's easy for any business to kind of take over that right of way and use it as their own. And to me, that's, and not to say there's an illegitimate argument for congestion, but to me, that's a legitimate argument for saying, hey, we shouldn't allow this in our neighborhood. You shouldn't be parking in the right of way. You shouldn't use that as your own. But if you create a physical barrier where you're only doing your legal business on your property, then that to me is a whole different concept, right? And so I just wanted to make sure I understood what you were talking about, and it sounds like it was the former, spreading out all over maybe property that's not yours, and then not maybe keeping your property.
I would agree with you.
Okay. Yeah, okay, thank you. I just want to understand that. So, other questions? Anything else to add at this point?
No, I appreciate your time.
Mr. Chairman, Councilmember Hancock is here and would like to speak.
Oh, nice. Oh, welcome.
I just snuck in the back.
Oh, good. Well, I say you probably your ears were burning because we were trying.
Yeah.
We knew that you had weighed in, and we're very glad to have you weigh in in person because that's nice. Thank you.
Yeah, absolutely. I was faced with the same concerns from the neighborhood this summer during my campaign, talking about the congestion on that street. So I've been up and down that street many times and have seen not only the congestion, mostly from the car repair shops across the street, but also the improvement on the side of the applicant. And when I went and met with the applicant, I was very hesitant because of the policy we have in place and, the 13 or some hundred odd feet of barrier between installing new auto repair shops. However, this was, as I witnessed, being a resident since 2006, an auto repair shop in the past. I did not know it had changed hands. I just knew that they were starting to clean up their act. So when they called me and asked me to approve this variance and told me about the brick wall, I then mentioned this at my 3 community meetings that I had in November, and I had no objections from any of the community members that came to my 3 meetings last month. And I also went to the owner of the business across the street. He owns the facility that hosts a few different repair businesses within one building, and he, who I thought would be the main objector, did not object at all. He was excited that a brick barrier would be there. He thought it would dress up the area, and he's really trying to get his clients to comply with the rules and parking, and they're doing a lot better about it as well. So I think with the fact that the neighbors didn't have any objection in November and the local business doesn't either, and I just see it as an improvement to that community. And the only other addition I'd like to add is, though technically the address is 305 Gallatin Pike South, it is on the rear of the building, so it's on Hickory Street, not immediately facing Firestone. It's the grocery store. And then one additional is this is a minority-owned business and a family business with the grocery store and the salon beside it. And we're really trying to support minority-owned businesses in Madison so that they can stay and make their living and not get sort of pushed out of the community.
Great. And so I guess one of the things that we look for, and again, I don't know how my fellow board members feel about it, but as we think about approving a situation like this, we think about the conditions. And so I'd mentioned to the opposition about, if it were conditioned, if they built the wall, how would that deal with congestion? And so would you be comfortable with the condition that was something along the lines of, if a variance were given, it would be given with the condition that a code-compliant wall, preferably brick, because I don't know if codes doesn't allow brick, it needs to be, we've had issues with auto sales businesses and fencing lately, so I just want to make sure we don't ask them to do something that's not allowed, but a code-compliant, preferably brick wall that would help alleviate any illegal parking on Hancock and keep the cars they service on their property. You'd be comfortable with that?
Yes, I think that's a fair condition, and it's a condition that the applicant himself introduced as, one of the reasons that they should be approved for this variance. So I think
and they
that's very
submitted drawings showing where that would go to.
Yes.
So. Okay, so were there any other conditions or thoughts that?
There was some tire storage previously. The, I guess, former occupant from years ago used to just pile tires up there on the side, and it was just a mess. And they're building a tire storage area next to the building, adjacent to the building, so it'll be neatly stacked, almost like books, I imagine. And that's, a great opportunity to also clean up that area. And it's, again, the way they're treating their property is having a direct impact on the property across the street, and they're starting to spiff it up too, which is nice.
Great. Awesome, thank you. Any other questions for the council lady? Hey, thank you so much for coming. Much appreciated. All right, we will hear back from the applicant.
would just like to say regarding the congestion, as y'all have discussed, we were in agreement with that area is a very congested area, which is why we had, proposed for that brick wall. I also included in the application because you said that you weren't sure if we would be able to have a brick wall there. There's the requirements for there's two requirements for the type of walls that we're allowed, and one of them is stone masonry. So I believe brick wall would fall under that condition. And yes, that's all I had to say in addition.
Okay. And so you were comfortable with the condition of the wall as proposed in your application, and tire storage being on the side of the building and not having public storage of,
Public storage of the tires. Yes.
I don't know how to word it, but basically not have the tires out in public like it had been in the previous repair shop.
Yes. Would there could that possibly be designed to where we'll be able to sign something that says we'll be able to do that within a certain amount of time period?
Oh, I don't.
Just so, because we've been out of business for some months now, so due to investment concerns and everything, we'd like to be able to get to the point where we'll be able to fund that and not take too much of a loss.
Okay, perfect. That's any other questions? All right, anything else to add?
No, sir.
All right, thank you. We'll close the public hearing.
Thank you.
And discuss.
I don't think that I could approve it because I don't see a hardship here, and it's too close to adjoining similar establishments, and I don't see a hardship, but I want to make clear for the record that I'm not basing my decision on the opposition, and I totally respect that Mr. Hoover is under directions from his client not to disclose our identity. He's doing what a good lawyer is supposed to do, which is not identify that. But I think that if people want to come oppose an application and they're not willing to identify themselves, I can give that no weight. But I can't, unless I have missed a hardship here.
Well, to me, I think, and again, I think that it's one of those, in that catch-all category that we often talk about, perhaps, but I think the history of the building was a repair shop. The opposition primary concern was congestion, which was addressed with the condition of the wall. The elected official that knows the district as well as anybody is in full support and has testified that it's a good thing for the district. And I think that because it's a historic, or it was a repair shop before the law went into effect, and I don't know that it's been shown one way or the other whether or not it lapsed for 36 months. The burden is probably on them, but I think that might be another hoop that they would have to jump. But I don't, in my mind, I don't think it's necessary to have to jump through that hoop to say, prove that it lapsed for 36 months and it isn't grandfathered. It very well could be a grandfathered use, and because of the council lady and the conditions to alleviate concern in that regard, I think it's a fair ask, and I'm okay to support it.
I was going to piggyback on Mr. Pepper's comment about hardship. I mean, this is a variance to a use, and usually we see variances that deal with the topography of the land or the characteristics of the land. So it's odd that it's coming to us as a variance and not as something like a special exception.
Well, it's a variance. There's a legal requirement that the distance between automobile repair shops is 1,320 feet, and they're asking for a variance from that legal requirement to allow it to be closer to an existing automobile repair shop. So it's not a use variance, it's a variance from the distance requirement.
But I understand that, but this kind of case that deals with a use of a building usually comes to us a different way. And I understand what you're saying, but it is a hard one to get our arms around what a hardship would be.
Yeah, well, and maybe that goes to, when you think of the hardship being a condition of the land on a distance requirement, you're never, going to have, I can't imagine a condition of the land that would cause that. And so I think it goes to those other categories. And, it reminds me of the sign case that, they wanted a sign too close to a residential area, but the residential area was a cemetery. And that was all that went on for miles. And so, it was a commercial street that was a little too close to the cemetery. And it's like, well, that's probably not, they're not going to be impacted by that. And to me, I think it's just the historic, if it hadn't had a history as a repair shop, which was testified to by both the applicant and the council lady, then I might have a different opinion on it. But because it had been a repair shop, and frankly may have been a repair shop within the time period to make it grandfathered, like I said, I just don't have a problem with it.
Well, man.
Any other?
I have some concerns when you're talking about a wall, and we've had a whole lot of these corner lots on busy streets lately, at least. Secondly, I'm having a hard time with the hardship. And
yeah, I don't think their wall goes to the corner, though. I mean,
but we don't know what it is.
Well,
You're making an assumption, and I'm sorry, Mr. Chairman, to disagree with you pretty strenuously, because we have other applicants that have come in with what was a very, very nice fence that you could see through that caused a certain concern too. I'm going to vote against this just because I don't see the hardship. It's not grandfathered because it's been changed in its nature. You and I have disagreement, and I respect you for that, but there's not 1,000 some odd feet between Firestone and this building, and I haven't seen anything put before us today that should rise to the level of saying it's a necessity, it's an undue burden, that they received advice from people that gave them bad advice. That happens all the time. So,
well, and that's fair enough. But just the fence, they do have drawings 3 of where they propose the fence to be, and it doesn't approach the corner. And again, it's just a hand drawing of I mean, it's bright red and it doesn't look like a fence, but I don't. If they put the fence where they have drawn it in their application, I don't have a safety concern with the corner because it's substantially away from the corner.
but is it then reducing the traffic congestion that people have been talking about? Mr. Hoover mentioned,
the council lady said it would, and I mean, and the council lady. And that was part of the issue of people parking in the right of way and the undeveloped street in terms of no sidewalk and that kind of thing. And it's fair enough to disagree, but that's where I was satisfied, was that council lady went to the business, walked the business, knew the street, talked to us about that, and said this would keep people from parking illegally on. Hickory, whatever the street was that started with an H.
So what I was going to say was, as I was listening to the applicant's presentation, I was thinking, as Mr. Pepper and Mr. Lawless, like, where's the hardship? And then as the chairman pointed out about the catch-all, I think because this building is designed as an auto shop. It hadn't been in a use for a while, but it was there. I don't know how long it's been there from the look of the building. It looks like it's been there a while. And because they're sort of just reopening it and cleaning up, and I appreciate Mr. Hoover coming and voicing the opposition, because I think parking congestion on a street like this is an important issue. And it sounds like the applicant anticipated that. and then created a solution for that, which I appreciate. And it also seems like the council person did a lot of legwork to talk to neighbors, have neighborhood meetings, get input. And so I think for all of those reasons, I can support this variance.
Would you mind making a motion, Mr. Chairman?
Oh, I was hoping you were pressing your button to do that. Well, I will make a motion that we approve the variance of distance requirements based on the historic use as an auto repair shop and the and the advice of the council lady and the effort that has been put into place to alleviate the concern that the opposition had raised regarding congestion, and that a condition of the variance be that a code-compliant wall of masonry or brick be built as submitted in the applicant's appeal as drawn on the 3 drawings, and that the applicant work to ensure that the tire storage isn't in the public view, and that it ultimately is provided as they described on the side of the building within 6 months of receiving this variance.
I'll second.
I have a motion, I have a second. Any other discussion? All in favor, say aye and raise your hand. All opposed? That passes 4-2. Good luck. Next case.
Next case, 2019-499. This is at property at 1710 Delta Avenue. This is a request for a variance from the minimum lot size requirements to construct 2 single-family residences. Before you now is a zoning map showing the zoning of the property is R6A. Is the applicant here for this case? You can go ahead and come to the front table, please. Zoning map showing the zoning of the property is R6A. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant. And finally, the current conditions of the property. Is there anyone here in opposition to case 499? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
Hi, my name is Alex Craw. I live at 604 Basswood Avenue in the Charlotte Park area, and I am representing the owner, MT Rental Properties, LLC. Mr. Servio has been a very good friend of ours, and actually I'm a general contractor, and he supplies our granites for all of our builds. About 6 months ago, he came to me with a property that he had owned for a few years and asked if I could help him build some new construction because that's something he has never done before. So I said, sure. And we went ahead and got a survey and realized that his lot was about 663 square foot short of having 6,000 square feet. When he purchased in 2016, he was under the impression that he could build an HPR or a duplex on this lot based on the zoning and all of the construction around him. And so I told him that based on the neighborhood evolving community policy and all of the multifamily, all of the other construction in this immediate area, that we would have a good chance in a variance in order to build 2 houses, with one house facing Delta Street or Delta Avenue and one house facing Jenkins. Like I said earlier, there's 6 newly built HPRs within a 500-foot radius. And in addition to this request, we're not asking for any front, side, rear setback or height assistance or variances. We plan on building one house that would face Delta Avenue and one house that would face Jenkins Street. Each would have parking and or a garage, so we would discourage any kind of parking on the street. And the only other item I'd like to point out is that the SP that was approved, three lots up from 1710 Delta at 1716 Delta, has a density of about 3.5 to 4 units per this size lot.
Have you talked to your council person?
I have not. But the owner, Servio, says he had approached him a few months ago. It's Mr. Brandon Taylor, who was newly elected. And he was generally supportive. He didn't have the exact details of 663 square foot being short of the variance, but he was supportive. Currently there, as you can see, there's an existing older home in below average condition. It is not a historic home, but the plans would be to demolish this house and have one house facing Delta and one house facing Jenkins.
Is Jenkins, I don't remember if this is a street or not, but we've had another proposal come up to us, and it may have been on Nassau and Jenkins, where they were going to have one face Jenkins and one face Nassau, and some folks didn't like it, and they said, oh, well, Jenkins is really just an alley.
It's not as wide as Delta Avenue, but it's wider than some alleys that I've seen. So I would say probably between your average alley size and the street size of Delta.
Yeah, I was trying to think, well, in some ways it makes sense to have it face both streets, but I'm just looking at the overhead we're seeing now, and I don't see anything really facing Jenkins. I mean, it's like, it doesn't look like, I mean, maybe it will at some point, but it doesn't look like now it's a common thing to have.
Correct. Yeah, I think there's a lot of parking that's in the rear coming off Jenkins, but and it's just a short, as you can see, that interstate kind of curves around. So there's only about 7 or 8, maybe about 10 lots that are there, and I do not think that one faces that side of the street, but most of them use it for parking.
Okay. Any questions? Anything else to add? Or?
No, sir. I appreciate y'all's time.
All right. We'll close public hearing. Thoughts?
I don't see a hardship. It seems like the request is for almost 700 square feet, and I did the math, that's almost 11% reduction. While I understand that this area is going through a lot of development, I don't know the size of those lots that permitted that development or any additional background on the SP. So without more other than this is a trend and without a hardship unique to this piece of property, I couldn't support a motion at this point, but I'm listening.
Well, I think that's anything, anything less than 2 or 3 you think is conceivably a stake issue, or anything 5 to 10 maybe does your neighbor have it and you don't. Anything over 10 is what is is there really something special going on? I mean, there's a little pie-shaped aspect of it where the one in the bigger piece above it may have made it, but then and you think, well, if then why not this? But then what about the 2 that are right below it in the tinier little pieces of pie? And should they get 2 because they're just even in a smaller piece? And I don't know. I mean, I think with it would take a lot more maybe council support. And I'm not saying that the council member isn't supporting it, as he said, but there's no record of that.
And there is a letter of opposition.
And we do have a letter from a Mr. Tucker who is totally against it and prays the board will not grant the request. So that sounds pretty strong that he really doesn't want us to do it. So what are any other thoughts?
I agree with Shanti. Ms. Davis.
Do you have?
Scares me just a touch.
I make a motion to deny the variance request due to a lack of hardship.
I'll second it.
Have a motion, have a second. Any other discussion? All in favor, say aye. Aye. Any opposed? That motion passes. Thank you. Good luck.
All right, thank you.
Case 2019-500 is the next case for the board to consider. This is involving property at 42 Shepherd Street. This is a request for variance from side street setback requirements to construct a single-family residence. Before you is a zoning map showing the zoning of the property as R6. Area photography giving you a sense of the surrounding area. This is the site plan that was submitted by the applicant, and finally, the photograph showing you the current conditions of the property. Is there anybody here in opposition to case 500? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
Members of the board, good afternoon. My name is Brian Musser. I'm the property owner at 42 Shepherd Street. I'm requesting a variance from side setback requirements due to the property being a corner lot with a narrow frontage of 25 feet. If I comply with the code as it stands now, I have a 3-foot setback on one side and a 10-foot setback on the street side, so hypothetically, I could only build a 12-foot house. For the side in question, if you can bring up the site survey, please. There is a 6'3" right-of-way between my property and the sidewalk, so the code states that I need a 10-foot setback from there. I'm actually requesting a 3-foot setback instead of a 10-foot. So with the right-of-way and the 3-foot setback, you're actually looking at a 9-foot 3-inch setback. So there used to be a house on the property that burned down. I cannot speak to the setbacks that that house adhered to. I live in Napier, and I've reached out to Council Member Colby Sledge by email. And though I haven't heard back from him, my understanding is that historically he has not supported building houses as narrow as that.
He did send us an email saying that he was neutral on this.
Understood, thank you.
He wasn't going to come out in support or against, so he's neutral.
Thank you, sir. My hardship, therefore, is that if not approved, my house will be so narrow as to be unsightly and unusual. So that's why I'm here asking for the side setback variation.
Yeah, we'd have one letter from a neighbor that was concerned about the height. And how high is this a really tall?
It'll be 34 feet, 10 inches, which complies with
2 stories, or is that, I guess 2-story, 3-story house? Or?
3 stories, sir.
Okay.
Yes, sir. I also, I have approximately, I think it's 13 or 14 signatures from neighbors that I went around.
I'm sorry, you have what?
13 or 14 signatures from neighbors.
Okay.
I'm not sure if that's included in the files that you have.
I don't think it's included in our packet, and so if you would just, do you have it with you?
Yes, sir.
Yeah, just if you'd give it to Jessica, and she can pass it down, and then we can have that for the record, too.
I went around to as many neighbors as I could to knock on their doors and show them what the house was going to look like and kind of inform them about what my plan was.
The house you're proposing, it's 18 feet wide? Is that right?
Yes, ma'am.
What is your frontage on Shepherd Street?
25 feet, sir.
It's 25 feet?
Yes, sir.
You know, and I guess I'm looking at this at the site plan, and it looks like to me that side setback on Thomas is 3.5. Is that right? You want 3, but it's what you showed 3.5. Am I reading that incorrectly?
On the street side, it's 3 feet, sir.
Oh, I see 3 feet over there. Okay.
So on the street side, code requires 10. I'm asking for 3.
And basically saying because there's a 6.3 foot right-of-way between your property line and the sidewalk, that would effectively give you close to 10 feet from the sidewalk, which would be an effective 10-foot setback.
Yes, sir.
Okay. All right, any questions? Anything else to add at this point?
No, I appreciate your time.
All right, we'll close public hearing.
This aerial is a little misleading. Where that red dot is actually on a house. That's my neighbor's house. So the property that I own is to the right of that. It's vacant land, yes.
Will you show us the current condition too, Nick? Yeah, this is the, I guess, a more accurate picture of what, and so that, yeah, so I've closed the public hearing, so I'm not going to have any questions. No, I mean, I think it's clear. I mean, I think it's clear. I mean, this, you know, there have been cases where we have said this is a legitimate hardship, especially when the right-of-way puts it really close. If they didn't have that right-of-way, it's rare that we just say without, you know, council or other support. There are times that we have said that we have denied requests like this in spite of the right-of-way because it had much more substantive neighborhood opposition, and in those cases was almost always more than one home. And so, I mean, it definitely falls into the realm of properties where the buildability of the lot comes into question with a true 10-foot hardship, which would make it, I mean, 10-foot setback, which would really make it 16 feet. So,
Yeah, I think a 25-foot lot is a buildable lot, and he has a 25-foot lot. And like you said, that setback would create an undue hardship in the fact that he would have to build a house that's 12 feet wide. And I feel that the house is far enough away from the road that it's not going to obstruct the view.
well, even if, and it appears that the sidewalk is new on that side, on the Thomas side, which means it probably is not going to, and there's a fire hydrant right there too, so it doesn't, on the other side of the sidewalk, so it doesn't look like it's going to be rebuilt anytime soon, but even if they were to go into that right-of-way and build a more compliant street to the new, a compliant sidewalk to the new code, there's room to do it, and the house is still going to be 13, 14 feet from the road on the side, which is not out of line with.
Who is the next door neighbor? Do we know? Is that one of the people that signed the petition in favor or not opposing it? I'm just kind of curious.
Yeah.
The next door neighbors, I mean, because
do you mind if I,
opposition we had from
yeah,
Joni Floyd, I don't know where that person lived, but then if the person that's living directly next door is not objecting to it, I'm just.
yeah. And let me, do you mind if I open the public hearing? Sir, could you tell us, the house next door, is that a new house or is that an old house?
It's an existing house. It was recently renovated. I've been in close contact with that gentleman, and he's in support of me building there. He's actually excited about having a lot of new builds in that street.
Okay. And so, and you're not at the setback, it doesn't, I mean, you're building within the legal setback on his side, but the concept that Tom wanted to know was do you know of any opposition from that person, and you don't?
No, sir.
Okay. I'll close the public hearing again. All right. I've been instructed to make a motion, so I will. Thank you. No, I'm just kidding. I know. Move it on. He listens to her. I know, exactly. Well, I'll move that we approve the variance from the side street setback to 3 feet, given that there is, the hardship on the lot is that it's a 25-foot lot. It makes it more buildable, and that there is an existing 6.3-foot city easement or city property right-of-way between the applicant's property line and the sidewalk, which gives an effective 10-foot side variance.
I'll second it.
Have a motion, have a second. Any other discussion? All in favor, say aye. That passes. Good luck.
Thank you.
Yeah, all right, we'll take a quick break and then
Then
continue
we will
on.
move on to the short-term rental cases. Then we will move on to the short-term rental cases.
Property, the owner-occupied permit was issued on June the 6th, of 2018. Permit expired 1 year later, June 6th, 2019. The host letter was sent on August the 5th of 2019. Estimated delivery was the 10th of that month. Advertisements were removed on October the 1st and October the 11th, as there were 2 advertisements. The BZA appeal was filed on that same day, on October 1. Operation dates were June 6th of 18 through September 30th of 19. Total document stays 53. After expiration, 13. And after the host letter was received, 4 document stays. There were no other actions taken against this property and no documented complaints.
And you said but you said, were there ads up now, or when did you find the ads came down?
There were 2 ads. One was removed on October the 1st, the second on October the 11th.
Okay, I'm sorry. So the last ad came down on October 11th?
Yes, sir, that's correct.
Okay. And you haven't seen it, it hadn't come back, and you haven't seen anything?
No, sir, I checked on it yesterday. They had not been reposted during that time.
Okay. Great. All right, sir, if you would state your name and address and tell us why you're here. I press the one with the little mic.
Check 1, 2. There we go.
Yeah.
All right. My name is Daniel Sadowski, 4201 Edwards Avenue in Nashville, Tennessee. I'm here to plead ignorance and throw myself at the mercy of the council. I did not know that my short-term rental permit expired. Had I known that at the time when I got it on June 6, 2018, I would have taken the appropriate measures to renew that permit. I have an Airbnb, an owner-occupied Airbnb, a short-term rental in my home, and we have had many guests. It's been great. I love doing it. It's something that I rely on the income for to pay my mortgage. I'm a musician here in Nashville. I'm a Canadian citizen, so I don't have much option for work. And this helps offset my expenses, my bills, my lifestyle. Pretty much allows me to live in this great city and pursue my career as a musician. Without it, it's very difficult to make my payments and to pay my bills. So it is something that I take very seriously. And again, had I known that the permit expired after a year, I absolutely would have taken the appropriate measures to make sure that I was not in this position. Again, pleading ignorance and putting myself in the hands of the council in this scenario.
Okay. And then when you removed your ads, middle of October, it looks like?
Yes. I had visited the zoning office September 30th. I have, as I said, I'm a musician. I'm touring quite a bit. Also over the summer, my partner's mother was ill and in the hospital in Canada. So we had spent several months over the summer up there with her. So I didn't see the letter until late August, early September, and by the time I had addressed it, it was late September when I went to the zoning office to rectify the situation. I was informed that I was late, basically. On that date, after September 30th, which is when I went to reapply for the permit, the next day, the following day, October 1st, I had spoken to Airbnb and VRBO, which are the 2 websites that I have the site listed on. Airbnb immediately took the ads down, and VRBO had said the same thing, though I found out a number of days later that they had not, for whatever technical issues they had on their end, had not taken the ads down and had not canceled the existing reservations. So I had to do that manually, and there were 7 existing reservations for October for my property, which all were canceled.
Okay. Any questions?
Yeah, I have a question. We
Sure.
don't get a copy of the permit in our board packet. Do you have a copy?
I have
That may
this is the,
May I see it?
absolutely, yeah.
It's okay. Okay, I see that there is no expiration date on the short-term rental permit. Is what I see on your permit.
Yes.
Thank you.
Then it just says it expires in a year, does it say?
Doesn't say. Do you see anything on there that I'm missing? It says issue date. Yeah, I guess you can pass it.
Do you have anything else at this point?
I do not know.
Okay, then we will hear from the opposition, and you will have 6 minutes after whatever the clock says.
Sure.
When they're done to
Thank
tell
you.
us what you
Thanks,
think
sir.
about all that. Sir, if you could identify yourself by name and address and tell us why you're here.
Yes, my name is William Omahandra. I live at 4200 Edwards Avenue, Nashville, Tennessee, 37216, in the Maplewood Heights area. I live directly across the address we're talking about the rental property. 4201, I live, my property runs right exactly in front of his house. And we're 100% against this permit. We feel it bring more crime in our area. And we also know that he only has a parking area for 3 cars in his driveway. And when they have a party, they create a problem with traffic. They'll have 12, 15 cars on the south. They'll be headed south on, coming from Maplewood Lane, south on Edwards Avenue. And they park one right behind the other. And I've come up through there myself. And it's a little rise there. You can't see till you get to the top of the rise what's coming. And we're going to have a head-on collision there for sure if it continues. Also, the fire department, they're big wide trucks, as y'all know, and they won't be able to get in there. The ambulance won't be able to get in there. Or the NES workers won't be able to get in there with these cars parked like they do. And we just think it's a bad situation. And on this short-term rental property, I'd like to know, does he stay at home at the time that this house is rented? And we'd just like to, we represent our neighbors. We got a lot of good friends and neighbors, and it's probably also where it's located. It's about 100 yards from Baltimore Baptist Church. And the property, when they have the parties, the cars line up in there, and the cars back all the way pretty close to the church, which is not good. And we just feel like there'd be fatalities there, because you have to come up to get in. You have to get in the left lane coming south. And if you do, you can't see till you get to the top of the hill.
And so, sir, you'd mentioned...
And you also, sir?
Yeah, you had mentioned that allowing him to have a permit would increase problems, but he has had a permit for over a year. Have you noticed any problems from his...
Yeah, we had a lot of problems. We had a lot of problems with the cars and parking there. And we've had noise in the yard. They don't make music in the yard, but They have people talking, walking around 2 or 3 o'clock in the morning, talking. You can hear them talking. From my house inside, I woke up several times and hear them talking.
Okay. Any questions? All right, sir. Did you have anything else to? I mean, you got time if you wanted. If you had other stuff to add, I didn't mean to interrupt.
Well, that pretty well covers it, I think. I appreciate it.
All right.
For your time.
All right, we appreciate you coming out too.
All right.
Did anybody else have anything to say?
Well, the main thing we're concerned
Yeah, ma'am, you need to, ma'am, hey, time out. You need to sit down, turn your mic on, tell us your name and address, and then you can have your say.
My name is Joyce Belafonte, and I live the 5th house down. And our concerns is, Mr. Omahanda's wife just passed away, and we had to have an ambulance out there to pick her up. And had the cars been up and down the street there, we wouldn't have been able to have gotten into her driveway. We knew nothing about the house being a rental home till we got a letter from you people.
Right, and so that, and I'll just say, if you, there are a couple issues you're talking about. One is, you know, and there are rules that other agencies besides this board deal with those instead of us, and one is, you know, is noise, and the other is, you know, if someone has a party or that type of thing. If you have a party in your home and you're there, you have a right to do that, and you just are not allowed to, you know, break the laws. And I can't tell you what the laws are because I'm not responsible for any of that. But I'm just saying that that's very different from the issue that we're looking at today, and that is this homeowner has had a permit to have a short-term rental, owner-occupied short-term rental in his home, which I just heard you say you didn't know he was doing until you got the letter. And so when we talk about any issues that you may have, the only issues we're concerned about are how it relates to the short-term rental, because that's the decision that we're looking at right now. Is it's like almost your car tag. You let your car tag expire, and the rule right now says you got to, in short-term rentals, you got to wait a year. And we're saying our hearing is to determine if he should be able to apply for that permit that he allowed to expire, because he testified a minute ago that he didn't know he was supposed to renew it. If he can do that sooner than a year. And so that's really kind of what we're looking at. And it's not that the issues that you're talking about aren't important and that we're not hearing them. It's just that sometimes we get, we get neighbors with a lot of different things going on in the neighborhood, and we're just trying to filter it and to say, well, what is it that we're looking at? And so that's why I was asking about, what is going on at the home when it's rented as short term, if you have that, and then if it's a party situation that they're not there and they're renting it to a bunch of folks and that kind of thing, and that's causing noise, and that's relevant to this permit. But if it's just, hey, we're throwing a birthday party, or we bring our musician friends and we have other events, and that's something that other agencies deal with besides us.
Well, like I say, what we're concerned about is the traffic, The emergency vehicles can't get up and down through there because it's hard for 2 cars to pass by there if you've got a van and a truck.
Right.
The road is not that narrow.
Yeah.
I mean, not that wide.
And I hear and appreciate the safety issues that you're talking about, and I'm just trying to figure out, well, how much of that is due to just, hey, I'm having a party in my house versus I'm renting it to other folks and they're causing it. See what I'm saying? And so that's just what I'm trying to figure out in my head. But don't get me wrong, I don't want you to think that I don't appreciate the issue that you're raising, because I totally understand it and appreciate it.
Well, they fly up and down our street all day long.
Could I say one thing?
Oh, yes, sir.
When he has someone, I don't know when he has people in renting or not, but normally there's 2 or 3 cars in his driveway, and that's all he can get in his driveway. So if he has rental people that drive cars, they're going to have to park on the street somewhere. And our streets have very little shoulder, maybe a foot wide on each side. Plus, there's no sidewalks.
Okay.
So thank you very much.
All right, thank you. Any questions? All right, then we will hear back from the applicant. And, you know, I guess in the application process, I know you are required to have parking, you know, on site. And could you address the parking and when you rent and, you know, who's there when you rent? And then maybe help us understand the distinction between, you know, whether it's you all having the party or maybe it's somebody else. And if you do have an event, then is that your event or is it your renter's event or that type of thing?
Sure. I'm very sorry to hear about your wife.
Thank you. I've never met Mr.
We've seen each other in the street.
And so just in the interest, like I said, in the interest of the rules we have up, sir, if you can cut off those microphones because we'll get an echo on channel 3, just cut off those microphones that you have. And I would encourage you all to meet each other after the hearing, but let's hear from him. We'll wind this hearing down. We'll go to the next one so we can get done with our day. And then maybe y'all can have that opportunity to talk afterwards. But if the applicant could, go ahead and tell us again what you were talking about, sir.
We have parking on site we have a long driveway that holds about 3 cars. When we do have a renter, we veer off to the side of the driveway, park on the kind of the front lawn, really. I would love to have a three-car wide driveway, but it's 3-car long. And to give the renter or the short-term renter access to the full driveway, we will park off to the side of the driveway, never on the street. The short-term rental is a 1-bedroom, 1 queen-size bedroom. It's a maximum of 2 guests. It's always been 1 car maximum, so there's never been more than 3 cars parked on the property. As I've mentioned, I'm a musician. My partner's a musician as well, so there have been times when we'll have people over during the day for writing sessions. Sometimes they will park 2 car lengths on the road, but that is completely independent of the short-term rental, and I'm happy to rectify that. That's an easy fix.
Are you usually home? Is someone home at your home when you rent the property, or do you ever rent the home without being present?
Someone's always home. We have there's a separate entrance for the rental with a code that we send the renters, so it's a keyless. It's a very easy process to get in, just so we don't have to be home to meet them. If, for whatever reason, one or both of us is out on the road for an extended period of time, we might miss their trip altogether, but that's a pretty rare occasion.
But you only rent the 1 room?
It's just the 1 room. It's a separate access from the house. It's a bedroom and a bathroom.
But you never rent the rest of your home, your personal space?
No, that's my living space.
And then the other issues that they talked about, I don't know that they're related to the short-term rental, but are there big parties and events that have cars down the street? Or?
We've never had a renter. It clearly says on our listing that parties are not permitted on our rental, and we don't generally host parties.
Okay.
A birthday, a Thanksgiving, but not a traffic stopping, shutting down the neighborhood kind of party.
Okay. Any other questions? Is there anything else that you'd like to add?
Again, I just a kind of an oversight on my part, and I'm taking responsibility for it, and will accept whatever penalty I'm given. But what I'm looking for is a reduction in penalty, not not complete absolution, but anything that the council can do to help me get this part of my life back up and running would be greatly appreciated.
All right, thank you. All right, we will close the public hearing.
Yeah, we've been hearing these cases, several of us, for 4 years. And I'm going to give a little speech if you don't mind here. We have, as of, I think still today, some discretion on assessing a penalty for different types of short-term rental property violations ranging from, and I made a list. In your case, you had a permit and you forgot to renew. There's another penalty for didn't know you needed a permit, once notified, did the right thing, stopped advertising, canceled old bookings. That's second violation. Third violation is didn't know needed a permit, once notified, stopped advertising and taking new bookings, but honored existing bookings. That's a third. The fourth is didn't have a permit and continued to operate. And the fifth one I wrote down was we used to see strikes against party house offenders. We haven't seen those in a while. And I say all that because, as I said, we were granted a couple years ago from Metro Council. By the way, we're the BZA, not the council. Different. We don't make the legislation. And so we've been for a couple years trying to fit penalties into these categories, and it's not been a perfect science, but it's been our honest effort to try to assess reasonable penalties. And so with that said, I think you fall into the first category, which is you had a permit and you forgot to renew. And it sounds like you did what you needed to do. You took down the advertisements. You canceled bookings. So I'm going to try this motion.
I like the way you put that out there.
I'm going to try it. That the zoning administrator did not err, and that we assess a penalty of 2 months from the date of filing, which was, I can get that here in a second.
10/1.
Which was October 1st. So 2 months would have actually have passed, wouldn't it? So I guess that I'll change that to be that you can apply again for your short-term rental property permit on Monday.
I'll second. I have a motion, I have a second. Any discussion? All in favor, say aye and raise your hand. Any opposed? That passes 4-2. All right, that passes, and good luck.
Thank you.
All right, next case.
The next case is 2000, didn't get up. Okay, I'm sorry. Next case is 2019-495 involving property, no, I'm sorry. The next case is 2019-489. It appears there is not an aerial view of this particular property, but if y'all need one, I can get you one next time. This is for property at 1129 Archer Street. This is an item A appeal challenging our cancellation of a permit due to a change in ownership. Mr. McBroom is here with the presentation on behalf of staff. Is there anyone here in opposition to case 489? Seeing none, Mr. McBroom and then the appellant will have an opportunity to speak.
In lieu of a picture, this is it's an area for which I'm very familiar. It's a row of townhouse-type condominiums, which are very uniform in nature, and there are numerous short-term rental permits issued there. It's a multifamily zoned area, so it can be permitted for any type of short-term rental permit. It was previously permitted with a multifamily permit issued on December 27th, 2016, expired 1 year from that from that date on December 27th of 17. A host letter was sent on April the 2nd of 2018. Advertisements were removed quickly at between April the 12th and April the 14th of 18. Ads were removed and reposted numerous times before the appeal was filed. However, I can attribute that probably due to the platform, the websites, because that's pretty frequent unless you absolutely have it completely removed from the site. Because during that time, there were no documented stays, with the one exception of 3 documented stays in the month of June of 2018, during a time that there was not a valid permit. On August the 8th of 18, multifamily STR permit was issued and ads reposted. 1/9 of 2019, ownership change, which was a quitclaim deed from the individual's name to a revocable trust of the same individual, thus canceling the permit. On September the 3rd of 19, cancellation letter was mailed. Ads were removed on the 5th of that month. On October the 4th, BZA appeal was filed. The operation dates, realizing that there were 2 permits issued for this property, were December 29th of 16 through April of 2018. And then the 3 stays in June of 2018, and then permit reissuance at August of 2018 through August of 2019. There were 14 documented stays after the claim deed ownership change, 0 documented stays after the cancellation letter was received. There was 1 email complaint for advertising excess occupancy in bedrooms on this property, resulting in a notice of violation on April the 28th of 17. The advertisements were corrected within the prescribed remedial time period, and the case was closed on June the 5th of 2017. There were no other actions taken against the property.
And so did the property change hands between April of 18 and August of 18?
No, sir. The ownership change was a result of it being moved from Joan Wilson and Brad Pennington to Joan Wilson, or perhaps it's to Joanne Wilson Revocable Living Trust et al.
Okay. So, and is it eligible? I guess it's a non-owner occupied.
Yes, it's.
Is it still eligible to be a non-owner occupied?
Yes, sir. It's in the multifamily residential zone, and at this time, it's still eligible for non-owner occupied.
So the issue is, I guess,
the issue at this time is just a reduction of the 1-year waiting period for operating without a valid permit.
Okay, yeah, because I mean, because I'm reading it, it's like we're challenging the zoning administrator's cancellation because of the change in ownership. Well, the ownership, I mean, I haven't heard from the applicant, but it seems pretty obvious that the ownership did change based on what you've said and the way the application is being, and the way the docket is applied. But assuming that the ownership absolutely changed, then they basically rented without a permit, without a valid permit, and then we're just trying to decide when they can reapply.
Well, the permit became invalid when the ownership change occurred. Now, it's sort of a gray area for people that actually do this because they generally do it on the advice of an estate planner or someone who's not aware that it affects their permit.
Right.
However, at the time that happens, it has been determined to be an ownership change, and therefore it cancels the permit once that transaction is completed. However, due to the number of transactions that take place in Metro, the change of deed is not updated frequently or in a timely fashion. So once that hits, then it's eventually picked up by zoning, and then the cancellation letter is sent. There's generally a lapse in between.
Right.
However, the permit is still invalid at the time the transaction takes place in the change in ownership.
Right, okay.
But in his defense, I will say that once he received the cancellation letter, he acted quickly.
All right, but a lot of times when we see change of ownership, it means that they're not eligible, but this is really just when can the applicant reapply?
Generally, it's because, in many cases, it's because they might have a non-owner occupied permit in some area where they no longer can obtain a non-owner occupied permit again.
Right, okay, cool. Any other questions for? All right, thank you. All right, if you could state your name, address, and tell us why you're here.
Hi, I'm Alfonso Alexander, 806 3rd Avenue South, Playlist Properties Management Company, representing the owners of this property. And just to give you our perspective on it, or to give you the details on what happened here, we went and reapplied for renewal on August 1 of 2019, along with several other properties, received back the renewal notices from the other properties, but not that one. On August 15th, we reached out to the codes office and asked, what what's going on with this particular one. And they said, well, we've been backlogged, so it'll probably be sent to you next week. Then on September 1st, we went, I don't know if it was exactly September 1st, but it was around September 1st. We went back and reached out again, and they said there's a problem with the property. A letter is being sent to you. When we received that letter, we were informed then that it was a change of ownership. We said, no, there's not a change of ownership. We reached out to the owners. They said they'd not done anything. And then they said, oh, but by the way, in January, we changed it from our names to this trust. And the reason being is the owner, one of the owners, Mr. Pennington, is undergoing cancer treatment. And for their, even though they have different last names, this is a married couple. And they wanted to make sure that the property was protected, so they changed it back in January. Had no idea that that impacted their permit, so we weren't aware of it, nor were they. And then at that point, we ceased everything and applied for the appeal. So my purpose is to try and see if we can go ahead and get approval to reapply for the permit.
Okay. Any questions?
So it's not disputed that there was a transfer of ownership into the revocable trust?
That is not in dispute at all. That happened at some point in January of 2019. I think the date was January 9th of 2019. We had no idea of it. We continued to operate. They had no idea that it was a problem because the trust is in their name. It's Brad Pennington and Joan Wilson, I can't pronounce that word very well in front of the microphone, trust. But those are the two individuals that the property was deeded in originally. So they didn't think that that was an issue.
And they did that, to the best of your knowledge, they did that on advice of counsel?
They did that on the advice of counsel, as they were concerned about his longevity and wanted to make sure that the property, when I mean his longevity, he's suffering from cancer.
Yeah.
And so they wanted to make sure that the property was protected and would be given to their children, is what they shared with me.
Any other? All right, anything else to add?
Nothing other than all I'm familiar with is what's happened since this permit. So the other things that the gentleman mentioned, I'm not familiar with that. That was prior to us taking over.
Okay, great, thank you. All right, we'll close the public hearing. Well, I mean, the most common scenario when change of ownership is the ownership changes and the property is no longer eligible for the type of permit it had. In this case, there was a change of ownership that was unknown to the manager, and and in almost every one of these cases that we get, unknown to the property owner, that would have an impact, and you understand why that is if you're not an attorney. So, to me, it's all about the behavior afterwards, and as soon as they found out, they took it down. It was over 3 months ago, so I don't have an issue with them applying.
Well, I mean, I want to compliment the management company because they saw it, jumped right on it, and did everything that they thought they could do to remedy it. However, it's still a transfer. The owner's got, in my opinion, some really bad legal advice. But we've had one of these other cases show up. What was it, yeah, we've had a bunch of these where there are a whole lot of estate planning lawyers out there that are too focused on a very narrow, I'm having a difficult time with a husband and wife, since if the husband, God forbid, was to die, it's going to vest in the wife if they own it T by E, but still, I don't think they should wait the full time, but I'm not ready to, I don't know if forgiveness is where we need to be, except I am going to compliment you and your company. You did a great job, and you've done everything you could. So I've said enough no's today. I at least want to get something positive coming out of my mouth up here.
All right. Well, any other comments? Well, I mean, to me, I'll look at the offense, and I think if we discovered the offense today and they completely stopped everything today. It's really is, I mean, there's no intent for bad behavior. There's no intent to break the short-term rental rules by changing the ownership for legal reasons. I do believe that if they were ineligible to apply for a permit on this property, that should stand because that's the law. And frankly, they changed ownership. And if we've had many cases, including one recently, where that was the case, where it was unfortunate that they were not eligible to keep their property as a short-term rental, but because they changed ownerships, they were ineligible. I do think it canceled the permit, but I don't think that they acted, we didn't ask if they paid their property taxes and all that type of thing, or paid their hotel motel taxes, but as a management company managing it, they most likely that's part of that process. So to me, I think, it's in that first quarter of 3 months after, the last rental, which has already passed. And, they have suffered a 3-month penalty already. So, I mean, it's not that they haven't, that we're not getting them over, but that's just where I am, so.
Yeah, in all cases that we hear, they do suffer, I don't know if suffer is the right word, but they do incur a penalty.
Incur a penalty.
Mm-hmm.
And to Mr. Lawless's earlier point, I do remember the applicant coming in several meetings ago. I don't remember why their case got pushed back, but I do remember them showing it. So I can say that they've been waiting for a while, and I think that's probably because they're trying to do everything right, which I do appreciate.
Thank you. Thank you.
So, I mean, I'll move and, again, see where it goes.
I would like to make a motion that we confirm that the decision of the administrator was correct, but that we allow them to get a permit, reapply for a permit on January, I was going to say 1st, but it's closed on the 1st, but the 2nd of January 2020.
Have a motion.
I'll second.
Have a motion, have a second. Any discussion? All in favor, say aye. Any opposed? That motion passes. You can reapply for a permit on January 2nd.
Thank you.
Thank you.
And I sure hope they stay with you guys because you do a good
Me
job.
too. Have a good day.
All right, last case.
Last case, 2019-494, short-term rental appeal for denial of a permit due to operating without a permit, so prior to obtaining one. Property is 6364 Old Hickory Boulevard, and the applicant is here. You'll have 5 minutes to make your presentation. Mr. McBroom will first make the presentation on behalf of staff.
Sorry, I just wanted to recheck my notes, but this was not previously permitted, and the host letter was sent on August the 4th of 2019. The advertisement was first posted on June 14th of 2019. The advertisement was removed on August the 22nd. Operation dates were 6/14/19 through 8/22/19. And as I did not have it noted in your package, but as I'm referring back to the documentation, there were 7 documented stays during that period. There were no documented complaints, and there were no other actions taken against this property.
And is the last documented rental you have sometime in August?
Yes, sir, it was in August.
Okay. All right, if you would state your name and address and tell us why you're here.
Good afternoon. My name is Rolando Yadira, my wife, Sandoval. We live in 6364 Old Hickory Boulevard. And really, we don't know that we need a permit for that. So we got a house. We don't got no children no more. So it's a big house for us. So we try, to make little money to pay the house faster. So, I mean, it's easy. That's it. I mean, we don't know that.
Did you get a letter you got a letter saying, hey, you don't have a permit?
Yes, and we, denied, or not denied, like cancel all the,
So any booking that you had, you canceled? And you haven't rented since?
no, sir.
Okay. And was the last time you rented it in August?
August. Yes. Yes.
Okay.
Yeah, I remember we were in Costa Rica that time. When we come back, we found the letter.
Okay.
So, yeah.
Okay. Any comments? And this is, are you all at home when you rent the property?
Yes, we live in there.
Okay. Any other? All right. Is there anything else that you'd like to tell us?
Not really,
Okay.
I'm sorry.
Okay. Well,
Can you remind me, did you have to cancel any bookings that you had scheduled?
I'm sorry?
Did you have to cancel any appointments or bookings that you had scheduled?
3. I don't remember how many, but I have many cancellations. In this moment, we in Costa Rica, when I coming, I found in the letter and I call IRB for cancel all the
bookings.
The bookings.
all right. If you don't, and you don't have anything else to add?
Well,
That's it.
All right, good. Well, all right, that's fine. We'll close the public hearing and discuss. It's, again, very few rentals. They spend more than almost 4 months out.
I make a motion that they apply on Monday.
Second. All in favor, say aye. Any opposed? All right, that means that you're eligible to apply for a permit on Monday, but you don't rent, advertise anything until you get that permit. But you can apply next week for a permit.
Thank you. Thank you for your time.
All right, good luck. We're adjourned.
I have one announcement.
Oh, wait,
before we
sorry.
adjourn. There was a case, 2019-478, that was properly noticed and should have been on the docket. Somehow it did not make it on the docket. We have advised the appellant, who showed up along with someone in support and was very gracious about the mishap, that we will put this on next meeting's agenda. So that's 2019-478. We're going to add it to the December 19th docket. Just
Okay,
wanted
and we can put that at the very top of the docket, too.
We'll put that at the top of the docket.
Yeah.
Thank you.
All right.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.